Well, the federal appellate courts are doing their job. In breaking news, the Seventh Circuit Court of Appeals has issued a new order 3-0 blocking the Trump administration and its hostile takeover of states like Illinois. Stay in your barracks, National Guard, federalized by Donald Trump, says the three-judge panel, 3-0. 2 Republicans and 1 Democrat have issued their new order. Donald Trump had run to the Seventh Circuit after he got a ruling he didn't like from Judge April Perry, in which she said the facts on the ground don't support the commandeering of the National Guard, the mobilization of the National Guard, the deployment of the National Guard. You don't have the level of violence that's required. You don't have a rebellion. You don't have another country invading, and you can execute your own laws with your own federal officers. You don't need the National Guard. And it's a reviewable issue. That was the first issue for the 3-judge panel. Can we even review this? Donald Trump says we can't, that we have to defer to him completely in the area of whether there's a rebellion or whether there is blood in the streets that make it impossible for him to execute on federal law. And they said, no, we get to review that. And then my favorite part of the order that I'm going to read to you from, and that I'm going to post on Legal AF Substack today, is when the 3-judge panel said, your own press releases from the Department of Homeland Security say that you're not having problem executing the laws, that you're able through Operation Midway Blitz to pick up thousands and thousands of people and detain them. So why do you need the why do you need the National Guard? I love when they use the press releases bragging by Kristi Noem and others against them. Let's do it. Let's cover this breaking news together on Legal AF Thursday. The judges are Judge Rovner, Hamilton, and St. Eve. Rovner, a Republican nominated by Reagan. Hamilton, a Clinton appointee. St. Eve, a Bush appointee. And what they've said is, we like what April Perry did, the judge, in coming up with all of the facts in this case. And while we are going to give great deference to the President of the United States, because that's what we think the law requires, about whether the facts on the ground are as they are, even the facts, and giving great deference to the President, he does not get to invoke 12406, that's a certain statute, and exercise a power over the National Guard. Because there is no rebellion, there is no domestic violence on the streets that make it impossible for federal officers to do their job to execute immigration law. Plain and simple. You've seen the video. You've seen what the ICE agents have done to attack Illinois protesting First Amendment expression, people on the streets. That's making it worse. But as the court observed, and as Judge Perry observed, there's only like 50 to 100 people at any given time in front of an ICE detention center. And it's all been handled by local law enforcement or ICE agents on their own. So no, you don't get to violate the 10th Amendment and take over the state guard in violation of state sovereignty and our foundations of our federalism. Let me read to you from the order on page 2 of the order. Because we concluded the district court's factual findings at this preliminary stage were not clearly erroneous and that the facts do not justify the president's actions in Illinois under section 12406. There's 3 prongs, none of the 3 prongs. Even giving substantial deference to his assertions, we deny the administration's motion for a stay pending appeal, except to the extent we continue our stay of the portion of the order enjoining the federalization of the Guard. Let me translate that for you. They made a ruling before we knew who the 3 judges were on an administrative stay. They stayed just one portion of Judge Perry's decision. They said that Trump could nationalize, commandeer the state militia, but he couldn't deploy. Mobilize, but not deploy. That means stay in your barracks. That means you're not going anywhere. It means you're not doing your patrols. We're going to let the power to be flexed for now, because that, we don't have to worry about putting that toothpaste back in the tube. But we're not going to let you put them on the streets because that alters the status quo, and we don't think you're going to ultimately win. We defer. We don't think that Judge Perry was ultimately erroneous in her fact-finding. So that was a decision that we got a couple of days ago. This is now after full briefing on the request by the Trump administration on a motion for stay. Other briefs are filed. Other Democratic state attorneys general filed their briefs. Some Republican states filed their briefs. We call them amicus briefs, friends of the court brief. And after that full briefing, now we've got the 3-0 ruling. 2 Republicans and a Democrat. Now, one of my favorite parts of the decision is when, yes, there were thousands of pages of record testimony and evidence and testimony that Judge Perry had taken in the court below, photos and videos and all of that. But what they really relied on was a couple of press releases of the Trump administration themselves on page 6. It says here that despite President Trump's federalization of Guard troops as necessary to enforce federal immigration law, Department of Homeland Security and ICE have touted the success of Operation Midway Blitz. In an October 3rd press release, they stated that they had arrested 1,000 people. In a September 26th press release, they said that the protest had not slowed ICE down and that they'd increased the deportation and arrest year over year. In other words, you've just admitted you don't need the National Guard. Dum-dum. Dum-dum was my commentary. And then they go off on the rest. They said, at best, it is First Amendment protest, not something that rises to the level of rebellion. Here's what they say on page 12 about the definition of rebellion. They said on page 14, applying our tentative understanding of rebellion and what it means to, and also what it means to be unable with regular forces to execute the laws. Here's how we come out. Even after affording great deference to the president's evaluation of the circumstances, here on page 14, we see insufficient evidence of a rebellion or danger of rebellion in Illinois. The spirited, sustained, and occasionally violent actions of demonstrators in protest of the federal government's immigration policies and actions without more does not give rise to a danger of rebellion against the government's authority. The administration thus has not demonstrated that it is likely to succeed on this issue. They did the same thing under the third prong about unable with regular forces to execute the laws of the United States. They cited back to the press releases. They said the Broadview Center is up and running. There's no facts that suggest that it's been impaired or impeded in any way. They said at this moment, we don't see anything wrong with the factual record created by Judge Perry, and therefore we are going to allow the mobilization, the mobilization, in other words, the commandeering of the National Guard troops by the president for now, but they stay in their barracks. It's like telling a child, it's Christmas, but you can't unwrap the toys yet. And you may never unwrap the toys because we may be returning them to the store, Donnie. Here's how Judge Perry, here's how we got here. Remember, this is separate from the cases that are going on in California and Oregon. California, we had a Judge Breyer in San Francisco. Part of his ruling was affirmed by the Ninth Circuit, and part was stayed. He then ruled that there was Posse Comitatus Act violations by the administration, meaning they were using the U.S. military improperly on domestic soil, and he issued an injunction. That's still up at the Ninth Circuit Court of Appeals, which is about 1/3 Trump appointees at this point, sits in San Francisco. Separately, Oregon, which also reports the Ninth Circuit, Judge Immergut made her ruling last week, 2 rulings, now 3 rulings, blocking the Trump administration from deploying on the streets of Portland or anywhere else any National Guard because the facts don't support it. That's up at the Ninth Circuit Court of Appeals. For right now, very similarly as the Seventh Circuit, they kept the troops in the barracks while allowing the commandeering federalization part. We're waiting on a ruling based on the facts on the ground, and that to Trump panel. How many Trump judges does it take to screw up a rule of law? Get ready for a bad decision coming out of the Ninth Circuit. I listened to that oral argument, and it's up. Actually, that oral argument is up on Legal AF Live. You can find it. And I think they're going to rule against Judge Immergut. Now we've got here Judge Perry's decision being affirmed 3-0 by the Illinois 7th Circuit Court of Appeals in their order. Let me just read to you from the beginning of Judge Perry's decision that got us to this appeal. And this is how they're all writing. Judge Immergut, Judge Perry, they're writing to the court of history. They're writing to future generations. They're writing to law students. They're writing to you and me in real time now, and to the courts and the appeal process, the Supreme Court and the parties. Here's what she wrote. Since this country was founded, Americans have disagreed about the appropriate division of power between the federal government and the 50 states that make up our union. This tension is a natural result of the system of federalism adopted by our founders. And yet not even the founding father most ardently in favor of a strong federal government believed that one state's militia could be sent to another state for the purposes of political retribution, calling such a suggestion inflammatory and stating it is impossible to believe that a president would employ such preposterous means to accomplish their designs. And that's a quote from the Federalist, number 29, Alexander Hamilton. She goes on, but I think you get the point. Judge Immergut made reference to the Federalist Papers, which is the framers and the signatories and others promoting the independence and the Constitution of the United States, writing at that time about how they saw the words on the page. Judge Immergut did the same thing. She quoted to the Federalist Papers, I believe to Alexander Hamilton or James Madison, and said, we have an overgrown president that's out of control. And how do we rein them in? That's the existential struggle that's up at these appellate courts. The ninth may rule for Trump. The seventh might rule against Trump. The ninth might rule for or against Trump again in California. All these cases land on the doorstep of the United States Supreme Court. And the question is, what are they going to do? I can guess, given their approach to the executive branch and the unitary executive theory, they've created a monster, a leviathan, that's no longer co-equal with the other two branches of government. The other two branches of government sit on the knee of the president based on how the Supreme Court has ruined federalism. Federalism as it relates to states and states' rights, which used to be a Republican thing. States' rights, everything is states' rights. Now let's see what happens when the state happens to be blue and Democrat and the president happens to be Donald Trump and he's doing a full frontal assault on their sovereignty. Posse Comitatus Act violation, anyone? 10th Amendment violation, anyone? What are you going to do, United States Supreme Court, and why should we trust you to do the right thing? We'll continue to follow it all right here on Legal AF. Hit the free subscribe button. Come over to Legal AF Substack, where I've posted both Judge Perry, her order, which got us here, and the new Seventh Circuit order for you to review up on Filings AF. Become a paid member, and that's how you become a full card-carrying member of the Legal AF community. That's the icing on the cake, the cherry on the sundae. So until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.